like to call to the table your legal interns. From time to time, they're kind enough to appear before this body and report on some of the various Delta-related cases that are pending. And we actually have a new intern to introduce to you, and so I figured since they're the ones that do all the real work behind the scenes anyway, it's good to give them some face time and some time for you to interact with them. So I'd like to introduce first Ms. Janelle Kradiger from UC Davis Law School, who's a second-year law student now, has been with us for, 2-3 weeks?
Almost a month
now. Like I said, almost a month now. And then you've met Tori Sundheim from McGeorge Law School, who's in her final year. And so they both are going to report very briefly and succinctly on a few cases that we have flagged for your attention that are of somewhat interest and related to the Delta Plan and the things that we do. So with that, Janelle, did you want to...
Can you hear me okay?
No, you've got to pull the microphone fully towards you.
All right, how's that?
Good.
All right.
That's good.
Good morning. There are two cases I'd like to bring to your attention today. The first is Light et al. Versus the State Water Resources Control Board. This is a case out of the Superior Court of Mendocino County. The decision was entered on September 26th of 2012. It is a trial court decision and therefore does not have precedence. However, it is important because...
What's it about?
It's about frost protection in the Russian River.
Okay.
All
Frost
right.
protection.
Yes.
You mean the use of water by grape growers
and pear
to
growers,
reduce
yes.
the threat of freezing, and the water board's rule that says they might be inappropriately or interfering with fish species by drawing out the water at a particular time?
That's correct.
Got it. Okay.
All right. It's important because it appears to invalidate the board's ability to issue blanket provisions on water users for unreasonable use. So you might be asking how these issues are relevant to the Delta Plan. We recognize that since this case comes to us out of Mendocino County, that is outside the council's jurisdiction. However, because of its potential implications regarding the board, public trust, and the reasonable use doctrine, it is important to keep this case on our radar. I would like to remind the council of two important provisions, the first being Water Code Section 85023, which states, the long-standing constitutional principle of reasonable use in the public trust doctrine shall be the foundation of state water management policy and are particularly important and applicable to the Delta. The second is from our California Constitution, Article 10, Section 2, which states in part, it is hereby declared that because of the conditions prevailing in this state, the general welfare requires that the water resources of the state be put to the beneficial use to the fullest extent of which they are capable, and that the waste or unreasonable use or unreasonable method of use of water be prevented, and that the conservation of such waters is to be exercised with a view to the reasonable and beneficial use thereof in the interest of the people and for the public welfare. So now I'll give a background of the facts of the case. In September of 2011, the State Water Resources Control Board adopted Section 862 of Title 23 of the California Administrative Code, which applies solely to the water diversions used for frost protection purposes by grape and pear growers. Frost protection is defined as a beneficial use under Title 23, Section 662.5 of the California Code of Regulations. However, Section 862 declares hundreds of these vested water rights subject to a condition that all water users be approved for diversion by a board-approved water demand management program. If a water rights holder does not comply with this water demand management program, the diversion for frost protection will be considered an unreasonable method of diversion. The regulation was adopted in response to concerns of salmonid fish strandings in the Russian River. The concerns arose after two stranding incidents in the spring of 2008. Upon investigation, the board found that the strandings were a result of the diversions for a river frost protection that decreased the flow of the waters to a perilous degree. Flow reduction resulted in a total of 31 documented salmonid strandings that spring. The plaintiffs filed this proceeding attacking the constitutionality of the new regulation, alleging that the State Water Resources Control Board exceeded their jurisdiction in adopting Section 862. The most important issue that the court addressed was whether the board was acting within its constitutional authority when it enacted Section 862, declaring the use of water for frost protection to be per se unreasonable for all water users. And the main holding of the court was that they granted the plaintiff's writ of mandate and declared Section 862 invalid. I have 5 specific findings of relevance to the council that I'd like to enumerate for you. First is, in using their regulatory power to define or otherwise limit the scope of prospective and existing riparian rights, the board was utilizing authority that lies exclusively with the legislature. Number 2, even in...
These are points raised by the complaining
court.
parties.
Oh,
or
yes.
the court.
Yeah, but the court, this is specific holdings that the court made. Number 2, even in an adjudicatory proceeding, Article 10, Section 2 places tight constitutional limits on the State Water Resources Control Board. They cannot issue a blanket decision limiting the rights of riparians throughout a particular water system without considering their individual reasonable needs, existing use, purpose, and specific plans for prospective use. Number 3, the public trust doctrine and the principle of protecting the public trust does not expand the authority of the State Water Resources Control Board to enact broad regulations such as Section 862. 4, whether or not a specific use or method of use is unreasonable is a factual inquiry and must be made on a case-by-case basis as the individual user. And lastly, each riparian's use is unique. Facts such as place of diversion, volume, time of use, effect on the stream stage, and relationship to fish habitat must be considered before declaring the use of water by a riparian to be unreasonable. So what are the implications of this? This was a pretty ambitious decision. It was pretty difficult to decipher also. It appears to prohibit or significantly restrict the board from issuing blanket provisions on all water users for an unreasonable use. Unfortunately, the convoluted conclusions made by the trial court don't leave us with a real clear definition of what the board's authority is, but it is apparent that there are loose ends that need to be reconciled regarding the board's authority under the reasonable and beneficial use and public trust doctrines. It's unclear what the board will do from here, but we will continue to monitor this case.
Questions? Did the court decision reference the history of disputes on the Russian River involving use by, for example, the city of Santa Rosa? Do you recall?
They didn't really talk that much about that.
Did they talk about the prior board order of about 5 years ago that ordered the city of Santa Rosa to reduce its draw on the Russian River because of impact on fish species? And the discovery after the city announced its press release, it's reduced its use, that it just substituted underground water source from the Russian River for surface Russian River water in announcing that they'd met the court goals, and the board said that was clearly insufficient. Did the case mention that at all?
They did not. The only mention of Santa Rosa was that they have different weather conditions than Mendocino. So.
Okay.
But
Mr. Nordhoff.
Janelle, how does this change anything that was in existence, the feelings, the views of the court before this decision was held down?
It was typically believed that the reasonable use and public trust doctrines afforded the board pretty broad authority for unreasonable uses, and so this runs contrary to that belief system, and so that's why it's kind of outstanding in that regard. But it doesn't seem to, it won't necessarily dictate what other courts decide on this issue.
Randy.
Do best management practices come into play at all in this court case?
Yes. What was interesting is that the court mentioned that a lot of the users of the water for frost protection had made many changes since the spring of 2008 to manage their water better, including having on-site ponds that they could divert water from. And that was one of the reasons why they said the board didn't specifically fact-find enough. But they had another program that they had delegated authority to that would do that investigation process. So.
Okay. All right. Further questions of Ms. Kettinger? I should have done this earlier, but starting with Mr. Johnston for quorum, please.
Johnston here.
Fiorini here.
Eisenberg here.
Natoli here.
Okay, we've got a quorum of 5. Thank you. Ms. Sundheim.
Yes, today I'm going to talk about two topics, really 3 cases.
Pull the mic closer to you, please.
Sorry. Today I'm going to talk about 2 broad topics, specifically 2 larger cases, and within the first there are 2 cases. So the first thing is the consolidated Delta Smelt cases. On the large consolidated Delta Smelt case, as you recall, Judge Wanger came down with a decision in 2010 about the Fish and Wildlife Service's biological opinion on the adverse effect of diversions on the Delta Smelt in 2008 and recommended reasonable and prudent alternatives to curb these adverse modifications in relation to the coordinated operations of the Central Valley Project and the State Water Project in the Delta. And these reasonable and prudent alternatives permitted the operations to continue. The issue in the case was whether the water users moved for a preliminary injunction against this biological opinion on the grounds that it was arbitrary and capricious and violated the Endangered Species Act because of that reason. In the district court, as you recall, Judge Wanger invalidated one component of the Fish and Wildlife Service's biological opinion, and that component specifically relates to the coordinated operations, and said that that component was invalid, and the impacts on the Delta Smelt are too adverse, and they need to come up with something else. I apologize. The district court that said that the Fish and Wildlife Service's determination was invalid, and therefore the projects didn't have to follow those alternatives. It's gone up to appeal, and we just heard oral arguments. Well, the Ninth Circuit has just heard oral arguments in September in Las Vegas. On appeal, the NRDC was arguing that the court should defer to Fish and Wildlife Service's determinations, similar to what Janelle was talking about with deference of the board. Here, it's deference to Fish and Wildlife Service, and NRDC is arguing that Fish and Wildlife Service is the expert. They have all of the scientists. They've done the research and run all of the tests to make the biological opinion, and that instead, the district court initiated a battle of the experts and went outside of its jurisdiction in doing that. Alternatively, the water users, which include Westland's San Luis and Delta Mendota Water Authority, Kern County, the Coalition for Sustainable Delta, Metropolitan Water Districts, and the state water contracts, perhaps others as well, argue that the best available science was not used and Fish and Wildlife Services did not do its job, that it was making an arbitrary and capricious determination. Because the oral arguments were on September 10th, we're still waiting to hear on that. And
was that a 3-judge panel of the circuit court? I just don't remember.
Yeah, it was. Okay. Yes. And the relevancy of this case specifically is that this is all about Delta Water. It's about the roles of the agencies, the roles of scientists, the role of the courts, and the role of water users on Delta Water, and trying to really figure out how to apply the co-equal goals in a legal and factual setting. Separate from the large consolidated case, to make this a little bit confusing is the narrow Fall X2 action case. First, what the Fall X2 action was component 3 of the biological opinion, so just a piece of the reasonable and prudent alternative on the salinity in the Delta water. And the Fish and Wildlife Service had determined that the line had to extend no more east than 74 kilometers from the Golden Gate Bridge in wet years and 81 kilometers in above normal years, and determined 2 parts per thousand salinity was the standard. After the large consolidated case in 2010, in that case, Judge Wanger was unable to make a determination on this fall X2 action, and the reason was because the water users needed an expedited opinion. So they kind of put it aside, said this is too complicated right now, and instead Judge Wanger came down with a decision a couple months later. And that decision, just on this issue, was that injunction should be enjoined, that it should not, that the decision on the Fall X2 action should be enjoined, that it should not be followed. And on appeal, the NRDC was arguing that the court shouldn't have even made that decision, that after it decided on that larger case, its jurisdiction was granted to the appellate court. However, the court decided on August 16th that the issue was moot because it was only on the Fall X2 action, which applied to the fall of a year that has already passed. And the reason I'm talking about this case is to highlight the fact that there are a lot of things going on with the Delta Smelt cases, and to kind of separate out these different things that you hear about in the news. You hear about Fall X2, you hear about the other consolidated cases. So this X2 issue is gone. It's moot. The court's decided that it's no longer an issue. However, you'll still hear discussion of the salinity line in the larger cases on appeal when the court comes out with its decision. And since it's a federal court and it doesn't follow state court procedural rules, there's no set date. It doesn't have to come up with a decision in 3 months. So we might not hear until a year from September 10th, maybe less, maybe more. And so we'll continue to monitor the effects of these Delta Smelt cases. But I'm going to move on to a different case. Are there any questions on these?
Don.
Yeah, just a question on the time. You said you might not hear it for a year, but is that the timeline? They have to render some decision within a year versus the 3 months? So there is some timeline, or it could be years.
My understanding is that they will likely come down within a year. That maybe it's possible to come to a decision within years, but speaking with an attorney, specifically speaking with Doug Obiji about it, and I don't want to quote him exactly, but from what I understand, it's likely that they'll just come down within a year. That's
okay.
what they do.
I don't know the legal procedural guidelines if there are any. But they'll get to their decision when they get to it. It's likely within a year, but they're not required to within some sort of statute of, I don't say limitations, but prescription as to having to render a decision within a certain time frame. They'll get to it as soon as they can, I guess, recognizing the complexity of what you just outlined. So
that's correct.
Okay.
When courts want to delay a decision beyond either a statutorily mandated or a rule proposed guideline, they often utilize the device, hearing oral arguments, delay, then ask for supplemental arguments on additional points, and so on and so forth. So there are ways to delay the process. They have to be a bit artful in the way they do it.
So, Tori, did you have just one more aspect, real briefly, to add? Was it the renewal of the water contract portion?
Right, that's
you want to mention, and then just briefly tie it all together, and so we can move on.
Right. So the next case is on the settlement and Delta Mendota Water Contractors contract renewal with the Bureau, and that case is the Natural Resources Defense Council versus Salazar. That was decided in the Ninth Circuit in 2012, this past summer. The Bureau regulates the Central Valley Project and contracts the rights that it has to water to various water users. In 2003, a biological opinion was determined. The biological opinion determined that the contracts were not likely to adversely affect the Delta Smelt. That opinion was stricken, and a 2005 biological opinion came out saying the same thing. Since then, we know that the 2008 biological opinion has also come out, but that pursuant to those cases that I was just speaking about, the coordinated operations part was invalidated. Therefore, currently, the 2005 biological opinion applies to the water users and the coordinated operations. This case is about whether the Bureau should have renewed the contracts that were up for renewal, specifically the Delta Mendota contractors and the settlement contractors. The Delta Mendota contractors are users who obtain water from the Delta Mendota Canal, and the settlement contractors are contracts that were made as part of a settlement with users who had senior rights over the Central Valley Project in the Sacramento River. So it was a way for the Central Valley Project to comply with California's priority law. The relevant issue is whether, the NRDC brought in action, among others, arguing that the Bureau violated legal obligations under the ESA Section 7 consultation requirements with Fish and Wildlife Services to conduct a study and then come out with reasonable and prudent alternatives to the current uses of the water. And the question that the court dealt with was, first of all, whether the NRDC had standing, which is something that, unless you want me to, I'm not going to discuss, and also whether the Bureau violated those legal obligations. The district court decided that the NRDC did lack standing, that contracts were not discretionary because the Central Valley Project had to follow. The Central Valley Project has to follow California state water law. And as part of that, the Central Valley CVPIA, sorry, these acronyms, the CVPIA has mandated certain requirements for satisfying these settlement contractors' water rights and water quality. And the State Water Resources Control Board also made a decision that affected these contracts. So the argument, and what the district court found, was that these contracts were not discretionary, that the Bureau could not renew them, and so they were exempted from compliance with ESA Section 7 because that's triggered by discretion. Because of that, there were also shortage provisions in the Delta Mendota contracts, and that argument was those shortage provisions allow for environmental water. So arguably, the operations would not affect the smelt, and they would be taken care of in other ways. The Ninth Circuit upheld that district court decision and said that there was no standing and agreed with it on July 17th. Immediately after, the NRDC filed for a rehearing or an en banc hearing. And what's interesting is that the panel ordered a response within a day, and that's what people are talking about now. Some say that this suggests the court may agree, and
May agree with what?
May agree and grant the rehearing, because generally, a court does not order a response unless it is seriously questioning its earlier decision.
Unless they don't.
Unless they don't. This is speculation. It's a possibility, not a probability, but it's worth mentioning, and it's worth understanding what the dissent had to say, because if the court does seriously question its earlier decision, then it may follow the dissent. And what the dissent says is that the plaintiffs have easily made a showing that they have standing, and that standard is only that they must show that they have a procedural right that, if exercised, could protect their concrete interests. They're arguing that the standing issue is much less difficult to meet than the current court has decided. The first issue on consultation, they're saying that if the Bureau were, Judge Paez is specifically the judge who wrote this dissent, he says that if the Bureau were to consult with the service, the Fish and Wildlife Services on the contracts, it might choose to provide less water to the contractors, which would improve the conditions of the Delta Smelt. Therefore, there is standing since consultation could advance that concrete interest, which is protection of the smelt. Second is that the Bureau's action was discretionary, and for two reasons. First, that the Bureau could simply not renew the contracts because the CVPIA and the State Water Resources Control Board do not require renewal of water contracts, and that the water contracts are separate from what they call Sacramento River settlement contracts, or just a part of that, and not specifically addressing it, and subject to interpretation that could go either way according to contracts law. Second, the Bureau could have simply renegotiated the terms in the Renew SRS Sacramento River settlement contracts protective of the smelt and the habitat. Therefore, it was discretionary. And also that the shortage provision in the contracts allow the Bureau to comply with this ESA, but just that they allow the Bureau to comply does not mean that they're required, or it does not ensure that that the Bureau will comply with the ESA. Therefore, consultation would be helpful and could potentially increase and improve the habitat and condition of the Delta Smelt.
Tori, could I just jump in real quickly? I'd like to tie a ribbon around all this stuff, and I think in a nutshell, thanks for the presentation, but this really proves one thing, that I'm a really mean guy for assigning all of this
It
stuff.
sure does. Yeah.
And
I should have boiled it down into a page and a half.
And I just wanted to say thank you for trying to boil all this down, because it really is confusing. And the reason that we bring it to your attention is not to befuddle you and overwhelm you with minutia.
Which you've done.
Which we have done. And that's always a good starting place.
Right.
But then you have to pull back, and you have to look at the big picture and talk about relevance. We've talked about the relevance of biological opinions, in essence, operating permits. We've talked about the role of science in biological opinions. We've talked a lot about litigation as being drivers of where we're at today with regard to water and ecosystem and the co-equal goals, and why this body was even formed. So this is long-standing litigation that has branched out. There's various tentacles of the real big issues that are still pending. So Tori's trying to explain some of the tentacles or the branches and some of the issues that are really important and that are on appeal right now with the Ninth Circuit Court of Appeals, a very respected federal appeals court. And hopefully we'll have some decisions soon, but there are issues that we have to monitor, and there are issues that are directly relevant to the Delta plan. So the minutia is difficult, it's painful, and I apologize to Tori and to Janelle for putting them through this, but it's not only a learning process for them, but we have to keep you informed as we get our product better and as we move into the implementation phase. So with that, I'd like to thank both of them and turn it back over to the chair.
Can I, my recollection is, or I guess my summary of this is that Congress adopted and the President signed the Central Valley Improvement Act in, 1994? 1994. And that was kind of coterminous with an amendment of state water project contracts in Monterey at the same time. And the federal law essentially, as I understand it, among other things, said the water for environmental purposes had to be another, 800,000 acre feet or something like that. And the litigation, this is my characterization, traditionally what happens is when that kind of an enactment happens, everyone says, well, you can't apply that to me. I had a contract in existence or something like that, and so, you should make other people adjust. It's a nice illustration of how the common belief that all you have to do is pass a law and it magically changes human behavior is clearly not true. By the way, I commend you for asking the ladies to try to tie the litigation discussions to our work. I think that's infinitely more helpful to us than just getting a straight report on the litigation. And hopefully it's something you'd continue in the future without abusing these ladies much more severely than you have.
Absolutely.
Okay, good. Thank you very much.
Thank you.
Okay, members.